what we're asking for is to be able to have our objection, which is a motion to modify, heard by this court. The court is free to grant or deny those. However, what opposing counsel is arguing for is denial of our right to have this heard within the court's plenary power. It's quite clear, Judge.
Levinger?
Well, first off, the motion.
Let me just ask one question that he raised, separate from the plenary power issue. So what is this about taxable court costs and not relying on the clerks, and what? I'm not sure I fully understand that.
Well, Judge, if I may,
Mr. Levinger.
You want me to answer that, Judge?
Yeah.
The judgment that the court signed on November 29th has the amount of taxable costs in it, $14,600 or something like that. We have backup information for that, put that number in there. They never objected to the number. What they're contending is that no number should have been in there at all. The court should have just awarded costs without stating what the number is. That's not right. I mean, I've seen dozens of judgments. I just saw 2 this week that put the number in there. And that's consistent with Civil Practice and Remedies Code 31007, which makes the litigants keep track of the costs and then allows the court to tax those particular costs. So, I don't think it's a hyper-technical objection. There's no basis for it, particularly when they've never said that amount is wrong or questionable.
Your Honor, the fact that we objected to the amount being there is in fact objecting to the correctness of that amount. We actually state that it is for the court clerk to determine the amount. So we are absolutely objecting to what that amount is. And we pointed out what Mr. Levinger stated is incorrect. The rule is quite clear, and it's actually reversible error for the court to enter and determine its own amount of court costs without relying on the bill of costs. That is directly from the rule. This is not interpretation. And the judgment also includes post-judgment interest on the appellate fees running from the date of judgment, which is also reversible error. Post-judgment interest can only run on appellate fees after a final determination at the Court of Appeals, because those are not actually fixed at this time.
I'm sorry, he's misreading the final judgment. It specifically excludes the appellate attorney's fees from post-judgment interest. There's no other way to read it. I specifically drafted the judgment to not run post-judgment interest on the appellate fees.
That is incorrect, Judge.
There's no other way to read it.
Because, Your Honor, what this says in paragraph 5 of the final judgment is that all of these paragraphs 1 through 4 and the appellate
it does not say 1 through 4. It says the sums awarded in paragraphs 1 and 4 get post-judgment interest. The sums in paragraph 2 and 3 are excluded. 2 and 3 deal with the contingent appellate fees, so they are excluded from the post-judgment interest. It's drafted absolutely correctly.
Okay, so let me ask a question here, Mr. Levinger, which is, you're going to have to defend this verdict on appeal. Is there anything that needs to be fixed on it, in your opinion, to make sure that I don't want to get reversed on some technicality? And so you're a very experienced, respected appellate attorney. I don't always agree with you, but it is what it is. I think you're doing an excellent job. Is there anything in the judgment that needs to be fixed that I can fix before it goes up on appeal, or do you feel like this is something that's defensible?
It's defensible. There's nothing that needs to be fixed. We will defend it, and on top of that, I just think the court's out of jurisdiction to do any fixing anyway. But there's nothing that needs to be fixed in my view.
So you would rather me not deny the motion for new trial? What are you asking me to do today? Just not do anything because I'm past your plenary jurisdiction?
That would be correct.
So don't make any rulings is your request.
That would be my request. Yes, I think that the motions that are presently before the court are untimely to begin with, and then secondarily, the court's plenary jurisdiction is run.
You know, what's before the court is our objections that we had filed that we simply just restated on the 11th. But it is the exact same arguments, it is the exact same authorities that were provided in our November 28th objection, which is a motion to modify. The court's got 75 days from then to rule. That would be February 12th. Mr. Levinger, I do not understand why he is making such a misleading argument. The authorities that we have put in our response make that the response to the objection incredibly clear. This is not the first time that Mr. Levinger has done this. If the court will recall, he also did this during trial when he made an objection to the HOA being able to bring a cross petition. However, and he cited the wrong rule. Rule 37 gives us that authority, and he repeatedly said, oh, there's no other rule that's there. Well, that's the rule we operated on this entire trial. And Judge, he's also seeking the taxable court costs against the HOA and the individuals joint and severally, but Mr. Zubark never had a claim against the HOA. So you cannot recover costs against a party you have a claim against. So again, this is going to be reversible error because, again, taxable court costs not determined by the court clerk and against a party that he had no claim. So I don't think this is defensible at all. I respect his experience in the appellate court, but I believe that this is error in his judgments, and it's going to cause this final judgment to be reversed.
Well, the latter point was wrong too, Judge, because under Rule 131, a successful party gets their court costs. You recall that the HOA asserted a counterclaim against Mr. Zubarek. It went to the jury. The jury answered no. In response to the counterclaim that Mr. Zubarek did not breach the contract. So therefore, we're entitled to recover attorney's fee. We're entitled to recover court costs from them too.
And didn't if I recall correctly, right before trial, didn't the HOA agree to, I don't know if it was indemnify or, I know they ended up defending the individual defendants. Is that kind of why they're joint several against the individual defendants?
Well, no, separately from that, the HOA had their own counterclaim against Mr. Zubarek that went to the jury. Their jury rejected it, and therefore we succeeded and are entitled to recover court costs.
No, that's not my question. Like, how are you able to recover court costs against the individual defendants as opposed to just the HOA?
Well, because we had a direct claim against the individuals and won. Right, we won on summary judgment, and then won with respect to the jury's award of attorney's fees, and then we won with respect to the HOA and their counterclaim. So they're jointly and severally liable for the taxable costs.
All right. At this point, I'm not making any rulings. I think my plenary power is expired, and if it turns out I'm wrong, then I'm not. It's going to be denied by operation of law because I'm not changing my rulings on this. I think the jury was within its, I don't know that I would have done exactly the same thing as the jury did, but the jury did what the jury did, and I'm not going to disturb what the jury did. So, all right, guys, I hope you have a great day. Be safe out there. I drove here to the courthouse, and it was a little bit icy. It took my bailiff almost 3 hours to get here. It is rough out there. The tollway wasn't too bad, but I-30 and 35 are still pretty bad. So just be careful, guys.
Well, we're thankful for Zoom.
Yeah. Yep. You guys be safe. Okay.
All right. Thank you.
Okay, Judge.
Bye-bye.
Thank you.
I hope Rhonda's okay. I thought she'd be here by now. She left at 8:48.
Oh my goodness.
Yeah, that's what it said here. All right, our next one is in about 10 minutes, Tony and Luz. And I'll be right back.
Okay.
Hey, Rhonda, you're here at the courthouse.
Hello?
Yeah, I'm here in the courtroom, so I didn't know you gotten here yet.
Okay.
All right. So what is the status? We have this hearing still set on the Couch versus Turner Massey Realty. Is that the one where Mr. Wood wanted to reschedule to do it in person? Is that?
Yes. I believe so. Let me see, because I told him to talk to you about it on Zoom. Because I think one wanted to reschedule and the other one wanted to go move forward. We'll get back to that email.
Is that this case or the Mini Gray case?
I think that's the 177. I think it has a bunch of sevens in it. Let me see. This is the the Mini Gray case I thought.
No, this is the Turner case. It's the one with Robert Wood.
Oh, the Wood. Okay, yeah. And that's at 10:30, so he should be logging in shortly. We'll give him a call. Let's see.
You want to call him and just find out if he's going to be joining us?
Okay.
Wood.
Yes, hi, this is Rhonda with the 6 District Court.
Hi, Ms. Benson, how's it going?
I'm good. Okay, well, we're on line now on the Zoom link, and the judge wants to know, were you going to be signing in soon so you guys can discuss the reset or whatever, or?
Okay, I just thought we just reset it. My client was okay with that. I talked to Mrs. Mendenhall last night and told her that that might happen. And so if we have to get on Zoom, I can do that.
Yeah, I think he does just want to talk to everybody real quick. So yeah, and then I'll reset it right then, whatever you guys decide to.
Can you send me a link and I'll pull up the computer?
Sure. Just send it to you, and here it comes. All right, thanks. Will do. Bye-bye. Is the other attorney on here? I can call him too.
We have somebody named Bobo. I'm not sure who that is.
Okay.
That's me, leaving Mendenhall.
Okay. Good morning.
Morning. We still Stockton? We still got a lot of ice?
Yeah, we do. It was tough getting here. I'm at the courthouse now. It was not as bad for me as it was for my bailiff. It took him over 3 hours to get here.
Yeah, my sister lives in Fort Worth and she's been working from home all week, so.
Let me contact Julie Lang. I think that's the other attorney on here. Hold on just a moment. I also email Miss Lane, so hopefully she'll be logging on too.
Morning, Judge.
Good morning. So we have Miss Mendenhall on the phone. Is there also an attorney involved at this point? Miss Lang, or is she still involved in this case?
No, the only attorney on this is myself and Mr. McGill, but we're on the same side.
So I understand you have a motion for judgment in this case. You want to reset that to do it in person? Is that
Yes,
right?
sir.
When is my plenary power expire?
Well, I think we've got some time because you signed the notice. I mean, you signed the order on the 28th of November. And we filed our motion, I think, on December 6th. So if we do it next Friday, I still think you have plenary power.
I will say this, that there is, all Friday hearings are set subject to trial. So if I'm in a trial, I could cancel the hearings. If you're close to plenary jurisdiction, I mean, it's your call. It seems like a pretty simple motion, but if you want to wait and do it in person, I'm okay with that too. I think you just run a risk.
Yeah, I don't have a spin calendar in front of me right this minute, but I'll definitely double check on the plenary power issue. And if there's a problem, I'll get back to Ms. Benson.
All right, Rhonda, go ahead and reset this next Friday at 10 o'clock, and it's subject to being canceled if I'm in trial.
Is that this Friday?
February 10th
February 10th, correct.
at 9 o'clock. Got it.
10 o'clock.
10 o'clock. Okay.
Okay, guys. Have a great rest of your day and stay safe out there, okay?
All right, thanks very much, Judge.
Bye-bye.
Bye-bye.
Thank you. Bye.
Bye-bye.
So we finished? Is that it?
Yep.
Yes.
I didn't want to leave before I had to. Thank you. I appreciate it. Bye.
We just lost to 10:45 because they want to go in person, so I reset them to the 24th.
Okay. All right. So that's great.